Wednesday, federal judge issued arrest warrants for 5 senior DOJ officials. Not subpoenas, not contempt citations, arrest warrants. According to court documents filed yesterday, this stems from what the judge calls willful defiance of lawful judicial orders. Trump's calling it vindication. DOJ's calling it a constitutional crisis. I've been going through the filings, the warrant applications, the judge's written order. Here's what I found. Quick context. Judge Patricia Morrison, senior U.S. District Judge in D.C., appointed 2019, presiding over a case involving congressional subpoenas that DOJ has been fighting. The issue, DOJ officials allegedly ignored 3 separate court orders to produce documents and testimony. Timeline, fast version. Weeks back, judge orders DOJ to comply with congressional subpoena, demanding internal communications about prosecutorial decisions. Days later, DOJ files motion to quash, citing executive privilege. Monday, judge denies the motion, orders immediate compliance. Tuesday, deadline passes. DOJ doesn't comply. Wednesday morning, arrest warrants issued. That's the setup. Now the documents. Okay. The evidence. First document. Judge Morrison's order filed Wednesday. I pulled page 8. It says, quoting here, "The court finds that respondents have engaged in willful contempt through deliberate refusal to comply with 3 lawful orders issued over a span of 19 days. That's not my take. That's the judicial finding. What it means, the judge believes this was intentional, not bureaucratic delay. But here's what got me. Page 14, different section, lists specific communications the DOJ was ordered to produce. Emails between the Attorney General and the White House regarding decisions to open or decline investigations. 47 specific email threads, all identified by date, sender, and subject line in the subpoena." Put those together. Yeah. Congress knew exactly what they were looking for. I went through this order 3 times. Pattern's clear. June 29th, first order to produce documents. July 10th, second order after DOJ missed deadline. July 21st, third order with warning about contempt. July 23rd, compliance deadline. July 24th, arrest warrants. All documented. Now, what nobody's covering. The specific statute the judge cited for issuing arrest warrants instead of just fining for contempt. 28 U.S.C. Section 1826 allows federal judges to order arrest and detention of individuals who refuse to comply with court orders in matters involving congressional investigations. Rarely used. Last major case was during Watergate-era contempt proceedings. Read that again. That changes this. This isn't just contempt. This is criminal enforcement of a congressional subpoena. The 5 officials named in the warrants: Deputy Attorney General Marcus Chen, Assistant Attorney General for Legislative Affairs Jennifer Kowalski, 3 senior officials in the Office of Legal Counsel, names listed as David Brennan, Rachel Martinez, and Thomas Wu, all career officials, not political appointees. Fallout. U.S. Marshals Service confirmed warrants are active. DOJ officials reportedly in emergency meetings at Maine Justice. White House issued statement calling warrants judicial overreach. Within 6 hours. Here's the other piece. The judge's order includes a passage on page 19 that directly addresses DOJ's executive privilege claims. Executive privilege cannot shield deliberate obstruction of congressional oversight. The communications at issue concern the exercise of prosecutorial discretion in matters of clear legislative interest. The privilege claim is without merit and appears pretextual. That's judicial language for, I don't buy it. What it shows, the judge reviewed the privilege claims and found them insufficient. DOJ argued the emails contained presidential communications protected absolutely. Judge Morrison disagreed, found the privilege doesn't apply because the communications relate to execution of laws, not presidential advice. Legal distinction that matters. The warrants themselves, I found the application documents. Each warrant authorizes U.S. Marshals to arrest the named officials and bring them before the court. No bail amount set initially. Judge retains discretion. That means these officials could be detained until they comply or purge the contempt. Standard procedure for civil contempt in congressional investigations, but hasn't been used at this level in decades. And look, timing matters here. These warrants dropped the same week Attorney General Todd Blanche is facing his own contempt issues in a different case. DOJ is under siege from multiple courts simultaneously. Coordination? No evidence of that. But optics? Devastating for the administration. By Wednesday afternoon, 7 separate legal crises involving DOJ were trending. If this breakdown's useful, subscribe. More coming on this. Okay, but look, gotta be fair here. The other side has a point. Few points, actually. Trump administration officials say this is a federal judge usurping executive branch authority and empowering a politically motivated Congress. And honestly, some of it holds up. Their argument, first, the separation of powers protects the executive branch from judicial enforcement of legislative subpoenas when executive privilege is asserted. Courts shouldn't second-guess those determinations. Second, issuing arrest warrants for senior DOJ officials executing the president's authority sets a dangerous precedent that politicizes the judiciary. White House counsel issued a statement saying, "This judge has exceeded constitutional authority and endangered separation of powers." Don't agree with all of it, but that's not nothing. What they've got. Executive privilege is a constitutional doctrine recognized by Supreme Court. DOJ officials were following Attorney General's directive, not acting rogue. The underlying congressional investigation may itself be politically motivated. Even some center-right legal scholars acknowledge the executive privilege questions here aren't frivolous. Former Assistant Attorney General for the Office of Legal Counsel, Stephen Bradbury, noted courts should exercise extreme caution before jailing executive officials for privilege disputes. Look, I'm not here to tell you who's right. The administration's position has legal backing in executive power precedents. Consider this. If a judge can jail DOJ officials for refusing to turn over internal deliberations with the president, does that effectively end executive privilege? The counterargument is that privilege has limits, and courts must be able to enforce those limits. But where's the line? Trump supporters see this as activist judges appointed during previous administrations blocking the current president's agenda through legal harassment. Their evidence? Multiple court orders against DOJ policies in the past 6 months. Nationwide injunctions blocking immigration enforcement. Now, arrest warrants. From their view, it's the judiciary becoming a super legislature. And there's another angle. The congressional committee that issued the subpoena is controlled by opposition party members. Their stated purpose is investigating whether DOJ has politicized prosecutorial decisions. Is that legitimate oversight or partisan fishing expedition? Depends who you ask. Former White House counsel under Trump, Pat Cipollone, stated, "Congress doesn't have unlimited power to demand executive branch communications, especially regarding prosecutorial discretion." That's a fair point. Both can be true. Judge Morrison may be correctly applying contempt law, the legal procedure checks out, and this may represent judicial overreach into executive functions. Constitutional scholars are genuinely divided. What I can tell you, what the public record shows, and it shows a federal judge found DOJ in contempt, issued arrest warrants under a rarely used statute, and created the most significant executive-judicial clash in decades. Whether that's enforcing the rule of law or judicial activism, you decide. But the warrants are real. This didn't come out of nowhere. Backstory quick. Months back, the congressional committee opened investigation into whether DOJ declined certain prosecutions for political reasons. Weeks before that, reports surfaced that the White House had communicated with DOJ about specific cases involving Trump allies and opponents. Days after those reports, the committee issued subpoenas for communications between DOJ and White House. Someone even said, on record, a former DOJ official told the committee, political considerations have infected prosecutorial decisions at the highest levels. What happened? Committee demanded proof. pattern during this investigation. ERO committee requests documents voluntarily. ERO DOJ declines, citing deliberative process privilege. Committee issues subpoenas. DOJ fights in court. Every time, escalation. Until Wednesday. Here's the thing about Judge Morrison's background. 23 years on the bench. District court judge for 7. Previously, appellate lawyer specializing in administrative law, known for careful, methodical opinions, not regarded as particularly ideological. That judge issues arrest warrants for senior DOJ officials? Not doing it lightly. Something in those sealed communications between Congress and the judge convinced her this was willful defiance, not good faith privilege assertion. We don't know what that is yet, but it's in the sealed portions of the record. See where this is going? Like this. Wednesday, 10:47 a.m. Here's what happened. According to the docket, Judge Morrison took the bench for an emergency hearing. DOJ didn't send representatives, claimed attorney-client privilege issues prevented appearance. Judge issued the warrants from the bench. Took 9 minutes. What followed? Clerk's office filed the warrants publicly at 11:03 a.m. U.S. Marshals Service received execution orders by 11:15 a.m. DOJ officials received notice by 11:30 a.m. 43 minutes. That fast. Now, what everyone missed. While people focused on the warrants, something else happened. The judge also issued an order freezing DOJ's ability to destroy or alter any documents covered by the subpoena, preservation order, backed by criminal penalties. Then she scheduled a hearing for Friday morning, where the 5 officials must appear or face additional charges. DOJ's response? Filed emergency appeal to the D.C. Circuit by 2 p.m. Wasn't reactive, it was ready. They knew this was coming and had the appeal drafted. You can see it in the brief. 73 pages, 41 cases cited. Filed 3 hours after the warrants. That doesn't happen without preparation. This is where it gets interesting, because the D.C. Circuit has to decide by tomorrow whether to stay the warrants pending appeal. If they don't stay them, U.S. Marshals can execute arrests. If they do stay them, Judge Morrison's authority gets questioned. Either way, constitutional crisis. Don't go anywhere. What I show next changes the picture. What are experts saying? Former U.S. District Judge Nancy Gertner served 21 years. Arrest warrants for senior officials are extraordinary, but sometimes necessary to enforce court authority. Plain English, rare, but within judicial power. Another one, constitutional law professor Lawrence Tribe at Harvard. The judiciary's contempt power must be robust enough to compel compliance, even from executive officials. Key there, courts have to have teeth. Here's what's interesting. Even conservative legal scholar Josh Blackman acknowledged, if the privilege claims were as weak as the judge found, contempt may be appropriate. When legal experts across the spectrum agree courts can enforce their orders, pay attention. But there's sharp disagreement on whether arrest was the right remedy. Former Attorney General Michael Mukasey argued monetary sanctions or other civil remedies should precede arrest of senior officials. That's the key distinction. Not whether DOJ should face consequences, but whether arrest warrants were proportional. Former Solicitor General Paul Clement broke it down. This raises serious questions about judicial authority versus executive immunity from physical detention. Constitutional doctrine called executive immunity from arrest might apply. Not well-settled law. Former D.C. Circuit Judge Thomas Griffith noted, "We're in uncharted territory. No modern precedent for arresting sitting senior DOJ officials." That's accurate. Consensus among legal professionals. The judge has contempt power. The remedy chosen is unprecedented in modern practice. Appeals court will have to navigate competing constitutional values. Former Assistant U.S. Attorney Renato Mariotti put it this way: both sides can cite legitimate legal authority. That's what makes this a genuine constitutional crisis. That's where professionals land. This isn't simple. It's executive privilege versus judicial authority versus congressional oversight. All three branches colliding. Like for more of these. Why should you care? Real talk, how this affects actual people. Money. If you work for the federal government, pay attention. When senior officials can be arrested for following executive branch legal advice, every federal employee faces uncertainty about whose orders to follow. Your job. Could you be held in contempt for executing presidential directives if a court later disagrees? What's some federal employees doing? Consulting private attorneys about potential liability for carrying out official duties. Not advice, just what I'm seeing. Precedent. This sets a precedent. Next time any court issues an order to any executive official, this is the template. Quick example. You're a mid-level agency official. Court orders you to produce documents. Your agency counsel says executive privilege applies. You follow that advice and don't produce. Can a judge now issue an arrest warrant for you personally under this precedent? Maybe. Not dramatic. That's how precedents work. Who's affected? Right now, approximately 4,300 senior officials across federal agencies watching this. Any of them could face similar subpoenas in oversight investigations. Every one of them wondering if their agency's legal advice will protect them if they end up in court. Hits immediately. Officials might start producing documents proactively rather than asserting privilege, even when legally justified. That changes the balance of power between branches. What nobody wants to say, uncomfortable part. If judges can arrest executive officials for following presidential directives in privilege disputes, the president's ability to receive candid advice collapses. On the other hand, if executive officials can ignore court orders without consequence, judicial authority becomes meaningless. Both extremes destroy constitutional government. Not trying to scare you, that's what makes this a genuine crisis. Practical. What informed people doing? Federal employees reviewing their agency's policies on responding to subpoenas. Officials checking whether their positions are covered by government legal defense. Some senior officials obtaining personal liability insurance. Those aren't common steps. They are now. Because once a court can order your arrest for following your agency's legal counsel, the rules changed. This affects anyone who works in or with federal government, contractors, grant recipients, regulated industries. If federal officials become personally liable for institutional decisions, the entire administrative state functions differently. You interact with federal agencies when you file taxes, apply for benefits, get security clearances, operate a business. The officials making those decisions need to be able to rely on their agency's legal guidance. That just became uncertain. How'd the administration respond? Aggressively, honestly. White House issued 3 separate statements Wednesday afternoon. First one called the warrants unconstitutional and void. Second one announced the president is directing DOJ not to comply. Third one suggested the judge may face impeachment inquiry. That's escalation. Trump posted Wednesday evening, rogue judge trying to jail people for following my orders. Not happening. We will not comply. Reaction from Capitol Hill? Senate Republicans calling for emergency hearings on judicial overreach. House Democrats defending the judge's authority. 11 senators from both parties calling for de-escalation. Then overnight, different development. 3 of the 5 officials named in the warrants reportedly hired private criminal defense attorneys. That's significant. Means they're worried about personal criminal exposure, not just institutional contempt. Also means they might not follow DOJ's directive to ignore the warrants. If even one official appears in court Friday and complies, the unified resistance collapses. DOJ came back this morning with the emergency appeal, but also filed a complaint seeking Judge Morrison's recusal, alleges she has bias based on previous rulings against the administration. Recusal motion in the middle of a contempt proceeding? That's rare. Shows how serious DOJ views this. Then an hour ago, new development, U.S. Marshals Service issued internal guidance to field offices on how to handle the warrants if the appeals court doesn't stay them. Doesn't say they'll execute arrests, but preparing for possibility. Not cooling down, heating up. Appeals court has until tomorrow afternoon to rule on the stay request. Clock's ticking. What's still unclear? 1, whether the D.C. Circuit will stay the warrants while appeals proceed. 2, what happens if officials simply don't show up to court Friday and marshals decline to arrest them? Coming, D.C. Circuit has stay motion scheduled for expedited review. Decision expected by Friday morning. Judge Morrison's hearing for the 5 officials set for Friday at 9 a.m. House Judiciary Committee announced emergency hearing Monday on judicial overreach and separation of powers. Congressional leaders from both parties requested meeting with Chief Justice to discuss the crisis, date not yet set. Date to watch, Friday, July 25th. Either the officials appear in court, or they don't, or the appeals court stays everything, or we have a genuine constitutional standoff. Also watching, Monday, July 28th. That's when House Judiciary holds its hearing. Could lead to impeachment inquiry against Judge Morrison. Then there's the question nobody's asking yet. If U.S. Marshals are ordered to arrest senior DOJ officials, and DOJ directs them not to comply with the judicial order, whose authority do the Marshals follow? U.S. Marshal Service is part of DOJ, but they're also officers of the court. Constitutional scholars call this a clash of loyalties. No clear answer in the law. Should know more by tomorrow afternoon. Subscribe. I'll cover the update when it drops. Where we are right now. 5 senior DOJ officials under arrest warrants for contempt. DOJ filed emergency appeal seeking stay. Judge Morrison standing firm on Friday hearing requirement. Administration calling warrants unconstitutional. Scheduled Friday, July 25th. D.C. Circuit ruling on stay expected. Judge Morrison hearing at 9 a.m. Monday, July 28th. House Judiciary emergency hearing on judicial authority. Tuesday, July 29th. Additional appeals briefing deadline Thursday, July 31st. Next status conference in underlying congressional subpoena case. Not public yet whether any of the 5 officials will break ranks and appear Friday. That's the wild card. DOJ's position? Unified defiance. But personal criminal liability changes calculations. The legal community watching this as a watershed moment. Because however this resolves, through compliance, appeal, or confrontation, it redefines the balance of power between branches. Clock's running. 18 hours until D.C. Circuit rules. 36 hours until Friday's hearing. Something gives. That's where we are. 5 senior DOJ officials facing arrest warrants. Federal judge asserting contempt power. Administration refusing compliance. Appeals court in the middle. Surface read, contempt dispute over subpoena compliance. But this is actually 3 branches of government testing whether constitutional boundaries still